Hi, I'm Matthew from Frontline Law. We specialise in a range of different legal areas, but one of the things that sets Frontline Law apart from other law firms is our special focus on military justice, and this includes the summary trial system. Now, lawyers aren't allowed at summary trials. We can't appear to represent people who have been accused of an offence and who are going through that process. What we do is we work closely with the defending officer and the accused to assist them in preparing their defence and maximise the chances of the right outcome for them. And we've had some really good results in this area. The purpose of this video is to assist the defending officer or the person who's accused of an offence and going through the summary trial process. It's not designed to replicate the 2-day military justice training program course that all defending officers, presenting officers and disciplinary officers go through. But it is designed to provide some hopefully helpful tips and guidance from a lawyer who has helped people through this process many times. A summary trial is a process that hears evidence against a person alleged to have committed an offence. Once the evidence has been heard, then the disciplinary officer, who's the person making the decision, decides whether the person is guilty or not guilty of the alleged offences, and if they are guilty of one or more offences, what the punishment should be. So the people involved in a summary trial are the disciplinary officer, that's the person making the decision, the defending officer, that's the person assigned to defend and assist the person accused of committing the offence, and the presenting officer, who's the person who presents the case against the accused, a little bit like the prosecutor, but with some differences. A very brief overview of the process leading to a summary trial is, first, an allegation of offending is made or it comes to the attention of someone in the NZDF. And this could be someone contacting the military police to complain that someone's assaulted them. It could be a supervisor saying that someone's late for work or has been insubordinate. Or it could even be the military police or other members of a unit detecting an offence, like they've come across someone drinking in their barrack room when they're not meant to be. This allegation of offending is then investigated at what's called a preliminary inquiry. And this preliminary inquiry is often undertaken by the military police, but it can be undertaken by the unit of the person involved as well. So they will talk to people who may have observed the offence, they will talk to the accused and they will interview them under caution, and they will collect whatever evidence they think is relevant. Once they've finished this process, they will then present all of this evidence along with a report to the alleged offender's commanding officer, who will make a decision about whether the allegation is well-founded or not. And this is an important part of the process, and it's got its basis in statute section 102 of the Armed Forces Discipline Act, which requires a commanding officer who has an allegation brought to them to determine whether or not it is well-founded. A charge is well-founded if there is some evidence in support of each of the elements of the alleged offence. And it doesn't matter if there's a conflict in that evidence. So for example, if some people say they saw someone punch another person and other people said, no, he wasn't the one punching them, then this allegation can still be well-founded because the time to resolve those conflicts in evidence is at summary trial. It's not during the well-founded allegation decision process. If the commanding officer decides that an allegation is not well-founded, that's the end of the matter. The alleged offender is advised and it's taken no further. Now that doesn't mean that a commanding officer can't reconsider their decision if additional evidence comes to light, and it doesn't stop another commanding officer, for example, if the offender posts to another position, making a different conclusion. But care needs to be taken with this because procedural fairness would dictate that there does have to be some justification for taking a different assessment of the initial commanding officer. If a commanding officer decides that a charge is well-founded, then they have a few options. They can refer it to an external prosecuting agency like the New Zealand Police or maybe Customs or Fisheries, an organisation that has enforcement duties and has the ability to prosecute offending. And this often happens if there's an alleged offence that has zero connection with the NZDF. But the much more common outcome, if the commanding officer decides that an allegation is well-founded, is that they say that it should be referred to summary trial. And that's done by recording the allegation in the form of a charge. And this is done using form MD 601 Delta, which is a form that lists what offence is alleged to have been committed, and it has charge wording, which gives a very brief description about how that offence is alleged to have been committed, and it contains other things like the service details of the accused person, and it contains all the documents that will be disclosed to that person. The person will be called to the military police station or maybe the unit to be formally charged. This means they will be given their caution, their Bill of Rights, and they'll be given the form MD 601 Delta, told that they've been charged, and they will have to sign the form. Another important thing happens at this stage in the process, and that is the person is given all of the evidence that is relevant to the charge against them. And I'll come back to what to do with this evidence later in this video. So once the person has been charged, there are some procedural things that happen. A defending officer and a presenting officer are appointed, usually from the unit involved, but they don't have to be. A disciplinary officer will be appointed as well. And this is often the commanding officer of the person involved, but it can also be a subordinate commander or a detachment commander. A subordinate commander is someone usually of a lower rank than the commanding officer who can hear more minor allegations of offending, and their powers of punishment are limited compared to what the commanding officer can impose. Once these people have been identified, then the work in preparing the defence begins. And I say begins because this does not necessarily mean the person's going to plead not guilty, but there does have to be work done by the accused and by the defending officer to make an informed decision, or in the case of the defending officer, give advice about whether the person should plead guilty or not guilty. You need to understand the evidence that exists in support of a charge. As a starting point, read the evidence, look at it carefully, make notes. Who is involved? Who saw what? Having this familiarity with the evidence is really important for all stages of the process. Once you've done this, then find the elements of the charge against the person. And you can do this by looking in DM 69 in the offences chapter, which lists the elements of the offences that are most commonly used. Occasionally you will find a person charged with an offence that's not listed in DM 69, and you might not know what the elements of that offence are. And in this case, seek advice from Defence Legal Services. While they can't give the accused advice that's specific to their defence, they should be supportive of the defending officer, and they should help them understand the law so they can go away and do the work in preparation for the defence. Once you know what the elements of the offence are, then think about the evidence you have read. What parts of the evidence relate to what elements of the offence? There will be some elements that you'll identify quickly as being very likely to be proved beyond a reasonable doubt. For example, the person being subject to the AFDA in the case of regular force members of the armed forces is not going to be in dispute. Every member of the regular forces is subject to the AFDA all the time. So for example, in the case of an assault allegation, are there some witnesses who say it was not the accused who was involved in the fight, it was another person who has not been charged? So these things might begin to raise questions about whether the accused is guilty or not. And so for these elements, highlight them. Put them aside as elements that could be weak, because we're going to do more work on those later. There are some other elements that might become immediately obvious as being able to be proved beyond a reasonable doubt. Things like the application of force to another person. There might be several different people who saw the accused punch or push the victim in the matter. The accused might have made admissions to the military police or to the unit investigator about what they've done. And so these things you might quickly put to one side as elements that are able to be proved beyond a reasonable doubt. But what you're more interested in at this stage of the process is what elements of the offence or the offences are weak. Are there elements which you've looked at all the evidence and you're not convinced beyond a reasonable doubt that the accused is guilty of that element of the offence? Now, there's a really important principle that applies to all criminal proceedings, including summary trials, which you need to be very familiar with, and that is the burden and the standard of proof. The burden of proof is entirely on the presenting officer to prove all elements of the charge to the high standard of beyond reasonable doubt. This means that the accused does not have to prove anything. They can sit there and say nothing. They do not have to give evidence. And it's up to the presenting officer to provide enough evidence to the disciplinary officer to satisfy them that the accused is certainly guilty. There cannot be any reasonable doubt left in the mind of the disciplinary officer. And if there is reasonable doubt, then the disciplinary officer must find the accused not guilty. So this is an important principle when you're considering the elements of the offences, because you don't have to prove that the accused is probably not guilty. You don't have to prove that they are likely not guilty. You just have to raise reasonable doubt for one or more of the elements. And if you raise reasonable doubt, even for one element of the alleged offence, then the outcome will be not guilty. For more complicated matters, you might want to consider making what is called an evidence matrix. An evidence matrix is created in usually Excel, but it can be whatever program you're comfortable with, where you list the elements of the offence, and then you look at the evidence and you take every part of evidence that's relevant to each element and you put it in that list. And so what you end up with is sort of 5 rows of data. The first column being the elements of the offence, and the second column being all of the parts of the evidence that prove that particular element or that are relevant to that particular element. So for example, if it's an assault charge and the element is applied force to the person of another, you're going to be taking out little excerpts from witness statements saying, I saw the accused punch him. And the accused might have said, yes, I did punch him. The complainant might be saying, I was punched by the accused. All those little excerpts are going to be put next to the relevant element. And the advantage of this is you can quite quickly see what elements are well supported by evidence and are likely to be proved beyond a reasonable doubt, but also what elements are weak, because not only do you put the evidence that supports each element, but you also put exculpatory evidence or evidence that tends to show that the accused is not liable for that particular element. So, applied force to the person of another, it could be a witness saying, I saw the accused standing in the corner and he wasn't involved in the fight. That would be put against that element as evidence showing the accused is not liable for that particular element. And an evidential matrix, it just helps distill your thinking, it helps work through the evidence in a methodical way, and it helps avoid missing any really important parts of evidence. And it also helps as a defending officer, you able to sit down with the accused and show them on paper or on a screen what evidence there is and how it relates to each element of the charge. And that will assist them in making a decision about whether they want to plead guilty or not guilty to the offence. So once you've completed a review of the evidence and you've reviewed the elements of the offence, the next thing to come up with is a theory of the defence. And a theory of the defence is how you might describe the defence to a person over a beer. It's just 1 or 2 sentences. It's really straightforward. It's not talking about any detailed evidence. It's just saying why they aren't guilty. So for example, the accused isn't guilty because he was acting in self-defence. That's it. The accused isn't guilty because he wasn't the one who punched the complainant. The accused isn't guilty because although he was late to work, he wasn't told to show up to work at that time. The accused isn't guilty because the drugs in his bag didn't belong to him, he didn't know they were there, he didn't control them. A really straightforward explanation of the defence. And this helps focus both you and the accused, and eventually maybe the disciplinary officer, on what to consider as they're looking through the evidence. It's also helpful at this stage to think about any procedural challenges that you might want to make. So for example, was some of the evidence collected via a search warrant authorised by a commanding officer? If so, are there any issues with the search warrant application? Was what the person said to the commanding officer applying for the search warrant correct, truthful, accurate? Was it a full set of facts? They didn't leave anything out that was relevant that might have made the commanding officer authorising the search reach a different conclusion? Were any admissions made by the accused obtained unfairly? So for example, were they cautioned at the beginning of the interview? Was the military police interviewer or unit interviewer being overbearing or aggressive in their questioning? Did the person being interviewed ask for a lawyer and they were denied a lawyer, yet they were still asked questions and that evidence was recorded? What I would suggest is just looking at the evidence and just using your common sense to think, are there any areas of unfairness about the process leading to that evidence being obtained? And if you think there are, then that could be a potential area of challenge. At this stage, it's probably the time to talk with the accused about whether they want to plead guilty or not guilty to the offence. It's really important to let the accused make the decision for themselves. Especially in the case of junior personnel, they can be very eager for you to tell them what to do. And this is understandable. They trust you. You're someone who's been in the service longer than them. They want to do the right thing. They don't want to do something wrong. And especially in the case of service people, they don't want to be seen to avoiding responsibility. And this is all very understandable. Your job is to help them make an informed decision. Tell them what the evidence is. Tell them what the elements of the charge are. Give them your opinion about whether each element can be proved beyond a reasonable doubt. If you're unsure, say so. It's not often that you can say conclusively that an element can be proved or cannot be proved. What's much more common is that you say, here is the evidence relevant to this particular element of the charge. I think that there are areas of weakness and these are X, Y, Z. And there's a strong likelihood that if the evidence is heard by the disciplinary officer in that way, they will reach the conclusion the elements has not been proved beyond a reasonable doubt. But there is a risk that either the evidence will come out at summary trial in a different way, or the disciplinary officer might not take the same view. And there is a risk that they could find the element proved, but there's a good possibility that they might not. And I know that that's a fairly general statement, and in some ways it's a little bit unhelpful to the accused because they just want to know what the outcome will be. But the point is, you don't know. A lawyer won't know. Your job is to help the accused make an informed decision about what to do. Give the accused time to think. If they want to make a decision straight away, that's absolutely fine. Sometimes an accused will come in and say, I'm pleading not guilty, and that's it, because they will know they haven't done it. Fair enough. But if they want to take overnight to think about it, if they want to talk to friends or family, if they want to seek legal advice, they're very welcome to. They should be given this time. They shouldn't feel any time pressure before they make a decision. If they've decided to plead guilty, then that does shortcut the process somewhat. You're going to move straight to preparing for sentencing. And we're going to talk about sentencing later in the video. If they choose to plead not guilty, this means you have to start to prepare their defence. You're going to return to your earlier work, and if you've done an evidence matrix, you're going to look at that, and you're going to identify the evidence and the witnesses that you will call in support of defence. It's also helpful at this stage to talk to the presenting officer because you want to know what witnesses they intend to call. You can also tell the presenting officer that the accused will plead not guilty to one or more of the offences. They will want to know for their own preparation, and it's okay for you to share this information. What you can't tell the presenting officer is any detail about the conversations you've had with the accused. You also shouldn't tell the presenting officer any detail about what the defence will be. You don't need to do this. You're not on the side of the presenting officer, you're on the side of the accused. and within the rules of the process, what you talk about with the accused should be kept confidential. Once you know what witnesses the presenting officer intends to call, then you can identify the other witnesses who aren't being called that you may want to call as well. Deciding what witnesses to call can be tricky, and a little tip is that it's not the quantity of witnesses that usually make a difference, it's the quality of what they say. And so if you've got 20 people in the room all saying the same thing, there's usually no good reason that you need to call all 20 of them, unless perhaps what they say is central to the issue and it is an issue in dispute. At this early stage, it's also good to think about timetabling. If you know when the summary trial will be held, it's good to warn out the potential witnesses that they'll be required so that they're not deployed on exercise or off to sea or something like that. So at this stage, you've spoken to the accused about whether they want to plead guilty or not guilty. You've also spoken to them about the evidence and the elements of the charges, and you've begun to talk about the theory of their defence with the accused. And this is another important area to make sure that you have instructions from the accused on. They need to decide what the theory of the defence is. For example, if they are adamant they didn't punch anyone, then it's difficult to run a defence of self-defence, because that would mean conceding that, yes, they did apply force to the person of another, but it was done in self-defence. And this isn't compatible with what their instructions to you are. So just make sure that they are aware of what the theory of the defence is and that they are happy with it. Just remember, this is their case and you're supporting them. And the final thing that you need to get instructions from the accused about is whether or not they want to give evidence. This is a really important decision if they're pleading not guilty. They don't have to give evidence. And if they choose not to give evidence, the disco isn't going to think badly of them. It's not held against them. They have the right to remain silent, and that's perfectly okay. What it does mean is that their version of events, their observations, what they have to say, won't be considered by the disciplinary officer. And this can be really important for some defences. For example, if the accused is arguing self-defence in defence of an allegation of assault, then their belief of the threat posed by the person they applied force to is really important evidence. And if they choose not to give evidence, then the disciplinary officer isn't going to consider what they believed at the time. The only exception might be is if the accused gave a military police interview and they said what they believed at the time at that interview. That can be played at the summary trial. So the upside of giving evidence is that what the person says can be considered by the disciplinary officer. But there are risks with giving evidence too, and in particular they are open to cross-examination by the presenting officer. So this means that the presenting officer can ask questions of the accused, they can ask leading and closed questions, and sometimes these can be quite aggressive within the rules. But it does mean that there is a risk the accused might respond in a way that makes them look guilty. My advice to an accused is just to be themselves, and if they're telling the truth and they take things slowly and they understand the question and they answer the question directly, then the risk of cross-examination can be mitigated. But there is a risk, and again, as with all decisions related to the summary trial, it's the decision for the accused. It's not for the defo to decide for them. This is also a good opportunity to decide if the option to elect court-martial is given, whether or not the accused will elect court-martial or remain at summary trial. And the right to elect isn't given at all summary trials, and it depends on the level of punishment that the disco thinks they might impose if the accused is found guilty. And the scales of punishment are found in Section 8 of DM 69 Vol 1. So have a look at those powers of punishment, and if this is a very minor offence, then it's probably less likely they will be given the right to elect court-martial. But if it is a moderate or serious offence, then there's a good chance they will be given the right to elect court-martial. So talk to the accused before the process, before the summary trial, so they understand what this means. You'll recall from your military justice training program that there are advantages and disadvantages of electing court-martial. The advantages are that you're in front of an independent judge who has a lot of experience in the law and they're very good at their job. They are represented by a qualified lawyer who can advance their defence in the most persuasive way possible. The rules of evidence are more strictly applied as well. But there are disadvantages. It costs more. Although the accused will be entitled to legal aid, they often have to make a contribution to the cost, which isn't very much, but it is something to be considered. The process can take longer to have a court-martial and to get through the court-martial process itself. The powers of punishment at court-martial are higher, meaning that they're not limited by what a disco can impose at summary trial. And then, sometimes most significantly, there's a degree of publicity when it comes to court-martial, meaning that even if it's a relatively minor offence, it's probably going to be front-page news for at least a couple of days. Another procedural point is that if a disciplinary officer intends on awarding punishments above a certain threshold, they must have obtained a specified certificate from a legal officer. So that's the preparation involved leading up to summary trial. At summary trial, the process is outlined in Annexes A, B, C and D of Chapter 7 of DM69, Vol 1. Have those things printed out in front of you at summary trial, because those annexes contain a flowchart of exactly what the process will do step by step, and it's a really helpful reference to have in front of you. But in summary, the process starts with the accused being arraigned, so the service particulars are read, the charges read, they're asked to enter a plea, do they plead guilty or not guilty? If it's not guilty for one or more charges, then the presenting officer will open his or her case, they will say what evidence they're going to call, they will then call those witnesses, ask them questions, the witnesses will be cross-examined by the defending officer, and then at the conclusion of the presenting officer's case, if the disciplinary officer decides that yes, there is a prima facie case against the accused, then the defending officer will be asked to commence their case. So they will give their opening statement, they will say what witnesses they're going to call, those witnesses will then be called and questioned by the defending officer, cross-examined by the presenting officer, and at the end of that process, each side will usually give a brief closing statement to the disciplinary officer. Now, the disciplinary officer can ask questions as well. They should be neutral, and they nearly always are. There are some examples of disciplinary officers being too aggressive in their lines of questioning or preventing the defending officer from doing their job, but this is pretty rare, and if you do have concerns, just raise those appropriately with the disciplinary officer. Everything's recorded, and I know that for defending officers it can be difficult challenging or disagreeing with the person who's above them in their chain of command, who is the disciplinary officer, but it's really important that you do this courageously, that you are always respectful and polite and you're acting within the rules, but just remembering you're there to present the case for the accused. You're not there to argue for his guilt or concede his guilt. You're there to do a job for the accused. That is your duty. Once the evidence from the presenting officer and the defending officer has been heard and there's whatever closing statements will be made, then the disciplinary officer will consider whether he or she is satisfied the accused is guilty beyond a reasonable doubt of the charges against them. They can do this straight away, but more commonly they will take a break. They could even take a break overnight and consider the evidence and make some notes about why they've made their decision. Now, the disciplinary officer isn't a judge, and it's not expected that they will give a decision in the same way that a judge will, but they should give some explanation about why they've found the accused guilty of the charges. Once this happens, if the finding is not guilty, then that's it. The process ends, everyone goes back to their place of duty. But if there's a finding of guilt on one or more of the charges against the accused, then the process moves to sentencing. And this should be something that you've prepared for earlier, because you don't have the opportunity normally to take a break and prepare for sentencing. You have to do it, even if it could be wasted work, because you may not get to sentencing. The presenting officer will give their submissions about what the sentence should be. The defending officer will give their submissions about what the sentence should be. And these should follow the guidelines in the Armed Forces Sentencing Committee guidelines. This reference contains a really helpful flowchart and template about what sentencing submission should cover. It exhaustively covers all mitigating and aggravating factors that could apply in a particular situation, and it's an essential reference for presenting officers and defending officers, and indeed disciplinary officers in making their sentencing decision. Once those submissions have been heard, the disciplinary officer might take a further break to consider what decision to make, or they might make it straight away. They will announce the sentence, they will tell the accused they have the right to appeal, and then that is the end of that particular process. After the sentence is announced, as the defending officer, it's worth finding a quiet, private space with the accused to talk about what has happened. They'll often feel quite shocked. Things have moved very fast. They want to understand what has happened, and you can help them with that. You can also talk to them about any rights of appeal that they might wish to exercise. So the accused has the right to appeal against the finding of guilt, against the sentence, or both. They have to do this within 28 days. And the appeal is made to the Summary Appeal Court of New Zealand, sometimes called SACNZ. Something we haven't talked about so far in this video is legal aid. So the Armed Forces has a generous legal aid scheme which does provide legal support to members of the Armed Forces who are facing charges or being investigated for allegations of offending. I've made a video about the limitations of the Armed Forces legal aid scheme, and I'll put a link above that you can follow. But in short, there is no legal aid available for the summary trial process, but there is legal aid available for preparing for a potential appeal to the Summary Appeal Court of New Zealand. And so it's worth mentioning this to the accused, that they will have the support of a lawyer if they choose to appeal and if they want a lawyer's help with that appeal. There is the time frame of 28 days, so make sure they're aware of that so they don't run out of time. They might want to know, if they appeal, will they be successful? We can't answer that now, and I would suggest this is advice that they should seek from a lawyer through the Armed Forces Legal Aid Scheme. So that's a relatively brief overview of the summary trial process and the role of a defending officer in supporting the accused. I want to end just by giving some general tips that, as a lawyer, I've picked up over the years that might be helpful to a defending officer as they work in support of the accused. The first and maybe most important one is preparation is key. A summary trial is not something that you can prepare for the night before or the morning or just wing. The evidence needs to be considered really carefully. You need to talk about it with the accused. You can seek advice from other people if you want to, not the presenting officer. You need to understand the case against the accused absolutely thoroughly. Your job is to be persuasive and concise. Volume of submissions and the amount you talk matters much less than what you say and the quality of your submissions. If you can say something in one sentence instead of 10, pick one. Tell the disciplinary officer what you are asking them to do. You are asking them to find the accused not guilty for these reasons, and then outline the reasons. The same for sentencing. You are asking the disciplinary officer to impose this particular sentence for these reasons. Always refer back to the legal framework. Refer back to the elements of the offence or the rules of evidence or the sentencing guidelines. Try very hard not to give your opinion to the disciplinary officer about what they should do. Start with the law, talk about the facts, and then apply the facts to the relevant law, and then end with a conclusion that is supported by the law and the facts as you've outlined. Be yourself. It's tempting to watch TV and movies, particularly American law movies, where they take a very dramatic and sometimes aggressive approach to questioning of witnesses or making submissions. Just be yourself. Most lawyers don't take this approach, and I found the most compelling and persuasive lawyers to be people who are just being themselves and talking directly to the decision maker in a persuasive way. The same applies to your questioning. My personal approach with questioning is to be very reasonable and take a witness methodically through each question and drawing them to the inescapable answer that I want them to give. Be empathetic and kind to the accused, and indeed to everyone involved in the summary trial process. Whatever the outcome, if you've done your job to the best of your ability, if you've acted within the rules, and if you've been kind and empathetic, then you can't go wrong. On a related note, don't take the outcome personally. Do reflect on what could have been done better. If there are grounds for appeal, say so. Even if it's something that you've made a mistake on, be transparent in that. Remember, it's not about you, it's about the accused. But don't take the outcome personally. It's an interesting process. It involves conflict. One side's going to lose, one side's going to win, if you want to use those terms. And that's just how it works. And that's not your fault necessarily. Seek advice. You've got people around you who are willing to talk things through and help you, whether that's someone in your chain of command who you know and trust. Defence Force Legal Services can give general advice, but they're not going to take sides. So they're not going to tell the defending officer or presenting officer what to do in terms of strategy. They can talk about the law in general. And you've also got us. So we're happy always to be contacted by defending officers or by people who are accused at summary trial to talk about their case. We're happy to have an initial consultation, which is no obligations and it's free. If you choose to engage us, we'll talk about what that means for you. But we're always happy to have an initial conversation to talk things through with you. So that's it for the summary trial system. Again, if you have any questions, you can contact us. And whether you're a defending officer or a person accused at summary trial, I wish you all the best with your matter. Thank you.